The disposition hearing is the most important hearing in the juvenile dependency system. Hi, my name is Vince Davis, and I'm an attorney here in California. I'm an expert in representing parents and relatives in CPS and DCFS cases here in California. You know, there is something called the dispositional hearing in a juvenile dependency case, and I say it's at the end of Module 1 of the statutory scheme. So in a juvenile dependency case, you have the detention hearing, then you have what they do in most counties is a receipt of report and what they call a jurisdictional hearing, which is not a trial. And then you can set the case for what's a trial either on the jurisdictional hearing, the dispositional hearing, or both. Now, the most important hearing is the dispositional hearing, and here's why. At the dispositional hearing, under Welfare and Institutions Code, section 361.3, the social worker must prove two things in order to keep the child away from you. Number one, the social worker must prove that you are a substantial danger, not just a danger, but a substantial danger to the child. And by the way, they have to prove that by clear and convincing evidence. The second thing they have to prove is they have to prove by clear and convincing evidence that there are no less restrictive alternatives. So I'm going to give you an example of what I did recently in order to win and get children back to their parents. In the first case, it was up in a Northern California county, and I subpoenaed from the department or the agency or CPS the person most knowledgeable on family preservation services. Now, family preservation services is a technical term used in federal legislation. It's money that the Department of Health and Human Services allocates to each state, each county, in order to keep families together so that children don't have to be placed in foster care. So let me give you an example. Here in LA, they have something called wraparound services, and it's where a team of counselors or teachers come out to your home 4 days a week, 5 days a week, to teach you how to parent your children, to give you and or your children individual counseling. Now, if someone's coming out to your house 4 or 5 days a week, they can check on your children to make sure that they're not in danger. That would be the type of service the court needs to look at in order for them to decide whether there are no less restrictive alternatives. And the sad thing is, in very few cases does the parent or the parent's attorney bring this up. So in that case in Northern California, I subpoenaed the person most knowledgeable from the department to come into court and tell us what services were available. Now, when I first served the subpoena, the county counsel, the attorney for the social worker, wrote me a couple, I'll say, unpleasant emails about that. Now, I didn't know whether they didn't want to bring in that person, if they didn't have that type of person, or if they just didn't want to let the secret out of the bag. But to my surprise, a person did show up. And it was obvious to me that this person had not spoken really to the social worker or the county council about the case. So I put this person on the stand, and it was a supervising social worker, to tell us and to tell the judge all the services that were available to make sure children didn't have to remain in foster care. I think the county council was shocked, the minor's attorney was shocked, and I think the judge was shocked to learn that all of these services are out there that nobody brought up. So you want to make sure you always subpoena that person so that you can prove that the social worker hasn't proved, by clear and convincing evidence, that there are less restrictive alternatives. You're probably watching this video because you have questions, and I answer questions like this every day. If you have a question, we give a free consultation. Please call us or call me at 888-888-6582, 888-888-6582. And to help us keep this channel going, please subscribe and like this video.